A very good evening to you, ladies and gentlemen. I'm honored and excited to welcome you to the BASL Webinar 1.9, organized by the Seminars Committee of the Bar Association of Sri Lanka 2021-2022 on the topic Mandatory Injunctions and Quia Timet Actions. This is the 59th webinar of the first webinar series hosted by the Bar Association of Sri Lanka and conducted on the Zoom platform. And for those who have been unable to register on Zoom, could also join by watching the live stream on the BASL YouTube channel. We would like to thank the Seminars Committee of the Bar Association of Sri Lanka, spearheaded by Mr. Rajiv Amarasuriya, Chairman of the Seminars Committee, who is the brainchild of the webinar series. Began last year post-COVID and going strong on its 110th webinar. While hosting a webinar series is by no means an easy feat, Mr. Amarasuriya is ably supported by the convener of the Seminars Committee, Assistant Secretary, Bar Association of Sri Lanka, Mr. Pasinda Silva, and the co-conveners, Mr. Pandula Vanyarachi, Mr. Oshan Uberatna, Ms. Anne Devananda, and Ms. Nikini Marketigama. I would also take this opportunity to thank the President of the BASL, Mr. Salia Peris, President's Council, and the other members of the Management Committee of the BASL for all the support and guidance. Today's topic is Mandatory Injunctions and Quia Timet Actions. As always, we have with us an eminent panel to share their experience and knowledge. It gives me great pleasure to introduce the esteemed panel and moderator for this session. Our first panelist is Mr. Ikram Mohammed, President's Counsel. He is a Senior President's Counsel in practice for the past 47 years. He is a past President of the Bar Association of Sri Lanka and a former lecturer in the Law Faculty and Law College of Sri Lanka. Our second panelist for this evening is Mr. Chandaka Jayasundara, President's Counsel. Mr. Jayasundara was enrolled as an attorney at law of the Supreme Court in 1991 and was appointed a President's Counsel in June 2017. He practices his law in civil and commercial litigation in the district courts, commercial high court, and the appellate courts. In the year 2008, he obtained an LLM in International Trade Law from the Law Faculty of the University of Colombo. Our third panelist this evening is Mr. Suren De Silva. Mr. Suren De Silva holds a Bachelor of Law degree from the University of Wales College of Cardiff, a Master of Laws from the University of College London, specializing in regulation of financial markets, law, and practice of foreign investments in emerging economies and privatization. He is a barrister at law, an attorney at law from the Supreme Court of Sri Lanka, and he has been awarded the Presidential Scholarship in 2003 for commercial law. He counts over 24 years experience practicing as an attorney at law and is a consultant counsel for DL and FD Serum attorneys at law. He serves as a director of the Colombo Stock Exchange and is a member of the advisory committee appointed by the Ministry of Justice to review and advise on the reciprocal enforcement of foreign judgments. Our moderator for this evening is Ayendra Wickramasekara. Mr. Wickramasekara counts close to 15 years in the bar and practices in the fields of civil, administrative, and labor law. Presently, he serves as a member of the Subcommittee for Commercial Law Reforms of the Ministry of Justice and is the convener of the Committee for Legal Education of the BASL. Members joining the session by Zoom are reminded that should you have any questions for our panelists, you may send in the questions through the Q&A chat box to reach the moderator. I will now hand over the proceedings to the moderator. Over to you, Ayendra.
Thank you very much, Shania, for that warm introduction. Good afternoon, ladies and gentlemen. Welcome to the 110th webinar organized by the Bar Association of Sri Lanka. As Shania mentioned, our topic for today is twofold, dealing with the subjects of mandatory injunctions and Quia Timet actions. When we think about these subjects, they are not those that are discussed very frequently in legal fora of this nature. Nevertheless, I believe firmly that they are of great importance, especially for those of us who are practitioners in the civil and commercial courts. Therefore, I am thankful to the Bar Association for having chosen this particular topic for discussion today and for having invited this esteemed panel of experts to guide us through it. That said, we will now commence our discussion for the evening by inviting our first speaker and most senior speaker, President's Counsel, Mr. Ikram Mohammed, who will give us an introduction into our topic and then go on to give us a detailed exposition on the subject of mandatory injunctions. Over to you, sir. Mr. Mohammed, you're on mute.
Sorry. Good evening to all. The heading is mandatory injunctions and Quia Timet actions. May I start with Quia Timet actions first? Now, Quia Timet actions are actions instituted in a court of law before something has happened to seek redress. Quia Timet action is distinguishable from the actions which are instituted for relief on the basis of a wrong that has happened. Now, if you examine section 5 of the Civil Procedure Code, it clearly covers Quia Timet actions. Now, Quia Timet word, the word Quia Timet in Latin means because he fears or apprehends. This action is instituted because he fears or apprehends that a wrong is to take place and to prevent that wrong. That is why that is called a Quia Timet. Now, that is seen from the very definition of the word action as contained in section 5 of the Civil Procedure Code. Action is defined as a proceeding for the prevention or redress of a wrong. Quia Timet is for the prevention of a wrong, not a redress of a wrong before the wrong could happen. And that is also couched within the definition of the word cause of action in section 5. Cause of action is defined to be a wrong for the prevention or redress of which an action may be brought. Therefore, if there is a person's apprehensions that a wrong is to happen, then he is entitled to base a cause of action on the basis that a wrong would take place unless it is prevented. Now, such action can be a regular action, which the relief can be given after the trial in a decree or in a judgment, which will fall within section 217 E and F of the Civil Procedure Code, or it can fall within section 54 of the Judicate Act. Now, 54(1) says, in an action where from the that the plaintiff demands and is entitled to judgment against the defendant, restraining the commission or continuance of an act or nuisance, the commission or continuance of which would produce injury to the plaintiff, he is entitled to bring an action to prevent such commission of an act or continuance of act. So that is before the action can take place. That is what is called Quia Timet action. Now, Quia Timet action, one of the first cases reported will be the case named Ceylon Land and Produce Company Limited versus Malcolmson's 12 Venella, page 16, where they have said if even nothing has happened to your action by way of a wrong by another person, but if it is threatened he is entitled to go to court to get that wrong, to prevent the wrong happening. Then in the section, Woodrunt and J has referred to the necessary ingredients as follows. One is the actual or imminent injury. And number two, prospective damage of a substantial nature, if not irreparable. Therefore, when you contemplate such an action, such a thing that could take place because of a person is threatening, because a person threatens that wrong to be committed, he is entitled to come to court. And the essentials are also given in detail by Justice Gratian in Heva Vitarna versus Chandravati, 53 NLR 169. That is, or that the concept can also be seen in the judgment in Felix Bandaranaike versus State Film Corporation, 1981, 2 SLR 287, where Justice Sosa has dealt with this matter, where relief could be given, when and where relief could be given in a contemplated defamation that is to take place. Now, such actions are very often instituted, and almost all injunctive reliefs are quite a bit, except for some of the mandatory injunctions. You go to court and you say, "This, I have the right, but this person is threatening to do these things. If such an act takes place, my rights will be prevented, injured, and therefore grant an interim injunction to prevent that action." So, in a normal action, you are entitled to seek relief by way of injunction, which is of a quite a bit nature. So, the main difference between a normal action and a quaterment action is a normal action is to redress, where you seek redress in respect of injury or a wrong that has happened. Quaterment is before such injury or wrong happens, you file an action to prevent that injury. And therefore, in those circumstances, the principle of law that is established that in quaterment action, you will not be able to make a claim for damages. So in almost interim injunction, you could see there is a concept of quaterment action. That is basically a quaterment action. And that I am sure learned panelist, President's Counsel, Mr. Chandaka Jayasuriya will deal in detail. Jayasuriya will deal in detail. Now, the other aspect with which I have to discuss is mandatory injunctions. Now, in our law, the injunctions, ingredients for injunction, the jurisdiction is set out in section 54 of the Judicature Act. And that section is held by, is said to be by in the judgments have held that that is the section under which injunction can be granted. There is no other section in a civil action. Now, that is seen in the judgment of Justice Victor Petra in Silavati Maldeva versus Kirtiratna, 1982, 1 SLR 385 at page 388. Now, in terms of section 54 of the Judicature Act, when you seek an injunction, it does not mention whether it is a restrictive injunction or a mandatory injunction. What an injunction has been defined by Halsbury as a judicial remedy by which a person is ordered to refrain from doing or to do a particular act or thing. The first is where you refrain a person by an injunction is called restrictive injunction. Where a person is ordered to do by an injunction is called a mandatory injunction. Now, section 54 of the Judicature Act, as all of us know, speaks of an injunction to be issued by court to restrain the commission of an act. The word used is restrain. You can issue, that is, they say it's the pivotal word is used, the use is to restrain a defendant from doing such an act. Therefore, the question has arisen whether a mandatory injunction of a mandatory nature not to restrain, but to compel the person to do something is available in the law of Sri Lanka. Now, in this regard, I think it is always advisable for us as lawyers to go through 3 learned articles published. First is the Interim Injunction in Sri Lanka, which is by late Justice Souza in the Judges Journal of December 1991 at page 68. Second article is Interim Injunction in the Law of Sri Lanka, also by Justice Souza in 1983, Biosocial Law Journal, Volume 1, Part 2, page 1. The third article is on mandatory injunction, a detailed article written by late President's Counsel, Mr. H.L.D. Silva, under the heading, Can the Courts of Sri Lanka Issue Mandatory Injunctions, which is in 1988, Biosocial Law Journal, Volume 2, Part 1, at page 7. Now, this question has always posed. The further question as to whether one could make the mandatory injunction within the meaning of restraint. Now, Mr. H.L.D. Silva, in his article, clearly points out that is permissible in our law and which ought to be permissible in our law because of the words used in section 54. It says, where the 54.1, where from the plaintiff demands and is entitled to a judgment against the defendant, restrain the commission or continuance of an act, not only a commission, but a continuance of an act or nuisance, the commission or continuance of which will produce injury to the plaintiff, injunction can prevent, restrain that defendant from committing or continuing such act. Therefore, it is the argument of Mr. H.L.D. Silva, which I think is quite correct to say, not only an injunction can be issued to prevent a person committing, but injunction can be issued to prevent a person from continuing to do the wrong thing. Suppose if a person has constructed the wall on the right of way of a person, the injunction can demand not to construct and also not to continue with the construction with objection, which would necessarily mean that he cannot keep that object or that nuisance or that wrong in existence, which means that he has to remove. Therefore, it is Mr. H.L.D. Silva's argument quite correctly that within the term restraint is included the right to make a mandatory order. Now, since this problem has been there, we as lawyers have always used to get a negative injunction in a negative form to say where a person has disconnected the supply of water. You don't seek an interim injunction, mandatory injunction, compelling him to connect the water. But we do, normally what we have done is to get an injunction saying where you pray that you are entitled to uninterrupted supply of water. So and so has discontinued wrongfully. Therefore, I am suffering irreparable loss. Therefore, I am entitled to an injunction to restrain him from continuing the disconnection. So therefore, he is therefore compelled to reconnect. Apart from that, we should be entitled to get a mandatory order to connect. Now, this was discussed for the first time in Pires versus Pires, where His Lordship Justice Udalagama held mandatory injunctions are issuable within the meaning of the word restrain, which is contained in section 54. Now, in that case, a person had filed an action immediately the moment there was an obstruction placed on a roadway. Before the injunction, and after the injunction, interim order was issued, and before it could be served, he had not only not complied with that, knowing that he had immediately put a fence across, a wall across the roadway. Therefore, in those circumstances, learned district judge granted the second mandatory order to remove that wall. which matter came up in appeal, and His Lordship Justice Udalagame held mandatory injunction demanding a positive act is to mandate only as a necessary ancillary to an injunction aimed at the protection or prevention of the subject in the same condition. It was when the cause of action arose. Therefore, His Lordship said an interim injunction restrictive in nature can be supplemented by a mandatory order in order to make it effective. And he went on to say in this particular circumstances, when justice demands, courts are not precluded from granting such relief of a mandatory nature. Both Mr. H.J. De Silva and Justice Souza accept the fact that mandatory injunctions are issuable in our law, although no injunction has been expressly mentioned as in the judgment in Peris versus Peris, which is reported in 2002 to SLR, page 128. Now, at page 131, His Lordship pointed out that today, with today's improved technology in the field of construction, by way of a cement block, wall could come up in hours. In such circumstances, before an injunction could issue to restrain someone from doing something the mischief complained of will have been done. All the injunction normally granted directing that something should not be done, exceptions, as in this case, could arise where something has to be done to alter the status quo, in which event courts could, as far as reasonably possible, intervene to undo it by grant of mandatory injunction. Therefore, where now His Lordship had taken the view that mandatory injunctions are issued as ancillary to an injunction aimed at the protection or prevention of the subject. Now, mandatory injunctions, Justice Souza points out in his article, the word restraining should also include mandatory orders. Now, the article said the restraint imposed may involve the performance of a positive act, like removing a fence recently built, filling a ditch recently cut, in compliance with the injunction not to obstruct the road or restore the water supply recently cut, in compliance with the injunction not to prevent the supply of water or pulling down a building recently erected, to implement the injunction not to do. The principle is that the court will not permit the restraint that imposes being rendered nugatory or looked on hopelessly, while the defendant attempted to forestall the order of the court by presenting a fait accompli. He says, in these circumstances, positive act mandated is ancillary or separated to ensure that the restraint is not defeated by a recent act of the defendant which forced the plaintiff to seek injunction. But our courts have not examined in detail what are the ingredients that are necessary. But this matter has been discussed in detail by the Indian courts. Now, those judgments have been examined in almost all the authorities. If I refer to one authority, Sohoni Law of Injunctions. The author in his third edition says, a review of these decisions therefore leads to the conclusion that there is no bar to the court granting interlocutory relief in mandatory form, though in doing so, the court should act with great circumspection, and such powers can be exercised only in rare and exceptional cases. No, not as a routine, but in rare and exceptional cases. And whether or not such a case comes within the concept of rare and exceptional is a matter for the court to decide on the facts of each case. Now, Indian cases have pointed out the purpose of a mandatory injunction is to maintain the status quo. And as in that, they have pointed out what the status quo will be the status quo at which the status quo of the party is as the date of the action. Then that also further to the question where a defendant, knowing very well that he is about to go to court, or that he had demanded the removal of this, and then or to prevent the construction or the commission of such an act, in order to nullify that, if he does, within couple of hours or couple of days. Thereby, he attempts to attend, and therefore, as a result of which, the status as a date of the action is not what was there, but what was brought about by the defendants. Courts have held the status would mean status quo ante before the defendant had wrongfully committed in view of the contemplated action. Therefore, the status does not necessarily mean the status as at that date, but the status, if it be changed in the ground by the defendant by his wrongful conduct, then the status would be the status that would have been there if not for the defendant's intervention. Now, that has been also somewhat established in our old case of Zahira Umma versus Abdul Rahman, 29 NL 411, where Fisher J discussed this particular principle at page 414 in this following manner. If a man with full knowledge or due warning of another's right or claim of rights does something which infringes or brings to do something which is completed, which if completed will infringe the rights of another, he acts at his own risk, and the court will interfere to protect the person whose rights are infringed or threatened by a mandatory or prohibitory injunction according to circumstances. Otherwise, the action will be, the relief that is sought could be rendered nugatory by the malicious act of the defendant. Now, the Indian Supreme Court, having in considering the requirements of mandatory injunction, in the case of Dora Kawasji Warden versus Kumi Sarab Warden, AIR 1990 SC 867, has held that the following test must be complied with in order to issue a mandatory injunction. One, the plaintiff has to demonstrate a strong case for trial, that it should be of a standard higher than that of a prima facie case. Now, in a normal injunction, we know our courts have held, one must establish there is a strong prima facie case. Now, for the mandatory injunction, according to what is laid down by the Supreme Court of India, that standard, but you must the standard of proof that is required is not a mere prima facie case, but something higher. In other words, you are trying to bring down or compel someone to do something before the final judgment. Therefore, you must clearly establish to court by somewhat for a greater or very somewhat a solid evidence that this is my right, which is breached by that person, by the defendant, by his wrongful conduct. For example, your right of way. This is the only way that you can have access to your house. If a person constructs a wall, surely one cannot wait until the final judgment. There is a very, very clear breach, and that is established by it's a clear cogent evidence you have. This is the only right of way you have. Then in those circumstances, that will satisfy the first requirement for a mandatory injunction. The second requirement according to the Supreme Court of India is the plaintiff has to establish that the grant of mandatory injunction is necessary to prevent irreparable loss or serious injury, which cannot be compensated by money. Now, in the case of a right of way, you know that cannot be compensated by money at all. Where if a person were to remove the stairway or the staircase, the person will not be able to have access to his house on top. So, in such circumstances, it is a monetary compensation cannot compensate the denial of right. Therefore, the law will intervene to bring about by mandatory injunction to restore the status quo which was there before the defendant wrongful act. The third requirement is the balance of convenience must be in favor of the plaintiff as against the defendant. That is, say, where the order, who will benefit more by the mandatory order? Is it the plaintiff or the defendant? If it is the plaintiff, surely the plaintiff is entitled and the court will take it to consideration. Now, in English law, the requirements have been discussed by Lord Upjohn in the household law decision in Redland Bricks Limited versus Morris, 1969 2 AER, page 576 at 579, that is referred to by Justice Sosa in his article. Now, there in that, if you go through that judgment, you will see how the requirements that are needed are not much different from what is the requirement that are needed in the English cases, in the Indian cases. So the basic requirement that you must have something more than a prima facie case that your right had been infringed. Secondly, if interim injunction is granted, you will suffer substantial irreparable loss, which can be compensated, and the balance of convenience must be in favor. Now, granting the interim injunction, you see, there are a series of English cases where such interim injunction, mandatory injunction have been granted, and in fact, the court has made order to demolish buildings which have been complete, which have been effected by the defendant in violation of a party's right. Now, if one can examine the judgments in Thompson versus Park, in 1994, 1 AER, page 477, then Luganda versus Service Hotels Limited, 1969, 2 AER, 691. Those two cases will establish the manner in which the mandatory injunctions and the circumstances under which the mandatory injunctions are issued. Now, in issuing in granting mandatory injunction, as I pointed out, the purpose is to ensure that the status quo is maintained. Now, how one could ask what is the manner in which in this interim injunction should be sought. Now, I think as lawyers, you have to examine the facts and the circumstances and then seek the relevant injunction. For example, if you say a person is trying to build a wall across my right of way, then you can ask a declaration that he is not entitled, I am entitled to my roadway without any interruption, and then restrain him from seek any restraining order to restrain building, and also seek another interim order, mandatory interim order, if any construction is constructed, to demolish the same. So it is, I think we have to take enough precaution to make sure that the injunction is properly couched. Then the requirements here, the manner in which interim injunction or the pleadings that are necessary and the documents which are necessary to be established, the procedure to be followed. I believe, you know, Mr. Surendi Silva will deal with those matters in detail. But I would say that, you know, interim mandatory injunctions, I think we as lawyers, we have to get used to arguing in favor of interim injunctions, and I think the courts must also make sure that in certain cases, but whatever reluctance, they must also establish this principle in a broad way. And then when you examine the judgments, you see courts have gone also on the basis, if a person were to do something wrong, then he should not be permitted to take the benefit of that wrongful act until the final judgment. He can't say, I have done it, therefore you can't do anything until final judgment. If it is so imminent, if it is expressly clear, then the court must issue, and we must also get the courts to issue those things. And also then question also will arise, if an interim injunction, mandatory injunction is issued, and the act that is to be, the act that is compelled to be done is completed, and finally the court were to hold that the defendant should not have been ordered to demolish, what will be the consequence? Now, in that rare instance, I believe, as in other cases, the act of court should not cause any harm or injury to a litigant. Therefore, in such cases, the person who suffers finally may be entitled in terms of the inherent powers of court to get the right to construct. Then one more question which arises, which is also not very clear. Now, in our law, an interim injunction must be issued only after notice. Now, here, can we issue a mandatory injunction by way of an enjoining order? Can the enjoining order be issued, mandating the person to do something pending inquiry? I believe that should be the law. But however, the question will arise, by the time the interim injunction application comes and order is expected to be made, the act that is mandated to be done would have been done. So the injunction judgment may not be relevant at that point of time. But still the court, I believe, theoretically is entitled to go on with that and to declare whether that order is right or wrong. By some chance, if that order is wrong, the restoration could be made by court. So although the mandatory injunctions are very useful, must be exercised, no doubt, very cautiously by court. And we must, as lawyers, make the court to exercise this relief, because this is a very useful relief. Thank you very much.
Thank you very much, Mr. Ikram Mohammed, for that very comprehensive exposition on the subject of mandatory injunctions. We will now move on to discussing the subject of Quia Timet actions in further detail. And for that, I would like to invite our second speaker for the evening, President's Counsel, Mr. Chandaka Jayasundara. Over to you, sir.
Thank you, Ayanda, and good evening, everybody. I will be sharing my presentation. I think Mr. Mohammed, in his usual way, has laid a very comprehensive base, and it is just for us to now go into the more detailed aspects of as far as I'm concerned, the Quia Timet injunction. So if we start from what a Quia Timet injunction is, the translation that you will find is that a Quia Timet injunction is sought for because the plaintiff fears or apprehends some act which will cause damage to him. Now, as Mr. Mohammed said, generally injunctions or enjoining orders and interim injunctions are obtained where the act or the conduct that you are complaining of and you want restraint has already happened or has started happening and is continuing. A Quia Timet injunction, however, or a Quia Timet action is, however, a situation where the conduct that you're complaining about to court has yet not happened. That is the main distinction between normal an injunction that you will seek, where you are seeking to restrain a continuation of a conduct that has already happened, as against seeking a restraint of something that has not actually happened, but you apprehend that such a damage has happened. So it is an anticipated wrong that you are trying to stop. Okay, so an injunction can be sought, therefore, in a Quia Timet action before the parties' rights have been infringed. That is the important fact. So, although it is provided in Section 5 and Section 54, which we will deal with fully later, the issue is that the wrong that you are complaining of has not happened. So if the wrong has not happened, what are you complaining about? Is it just your imagination? Your apprehension might be just in your mind. So what are the criteria that the courts have now laid down for some time now as to a situation where you are going into court on an apprehension of a wrong which has not actually happened. Okay? So the law therefore provides that a quatimate injunction can be granted where the conduct of the defendant or the wrongful conduct or act of the defendant is only threatened. However, there is a risk that if that injunction is not granted, the wrong that you're complaining about, that is your actionable wrong, will be committed. So this is more in the framework of a preemptive relief that you're seeking, that before you actually incur the damage, you are seeking a relief to stop something wrong from happening. So one of the earlier cases, English cases of Redland versus Redland Briggs, says it is to prevent the jurisdiction of the courts being stultified that equity has invented the quatimate action, an action for an injunction to prevent an apprehended legal wrong, although that legal wrong has not committed. Now, that has been accepted by English authorities as well as our own authorities, but the jurisprudence or the power to grant such an act, grant such an injunction, is there in Section 54 of the Judicature Act. Now, I have paraphrased it, more deleted the parts of Section 54 with regard to the conduct that has already happened or the wrong that has already happened, and you're seeking a restraint of the continuation of that wrong, to see whether Section 54 permits this sort of injunction where the wrong is yet to be committed. So Section 54(1)(a), this is well known, but for the purpose to put the discussion in context, 54(1)(a) says that the plaintiff is entitled to an interim injunction or an injunction where from the plaintiff demands and is entitled to a judgment against the defendant restraining the commission of an act or nuisance, the commission which would produce injury to the plaintiff. So it is in the future. 54(1)(b) with regard to interim injunctions in pending actions, that the defendant during the pendency of the action threatens or is about to do or procure or suffer to be done an act or nuisance in violation of the plaintiff's rights in respect of the subject matter. So there 54(1)(a) speaks at the beginning of the case, when the action is instituted. 54(1)(b) speaks of during the pendency of the action, and 54(1)(c) again specifies that the defendant during the pendency of the action threatens or is about to remove or dispose of his property with intent to defraud the plaintiff. So the law, therefore, not only the authorities in England and in Sri Lanka and in India, or while recognizing Section 54 of the Judicature Act specifically provides the provisions for a quatimate action. So the issue then is, so in such a situation, Section 54 provides that the court may grant an injunction. You can see the wordings again paraphrased, from committing any such act or nuisance, doing any such act or nuisance, or removing or disposing of such property. All matters that can be contextually used for the restraint of a wrong or restraint of conduct that is yet to happen. So again, the biggest issue that faces a litigant, and in fact lawyers who seek quatimate injunctions, is that you're actually trying to convince the court that although this has not happened yet, unless you stop it and by an injunction, this will definitely happen. And if that conduct happens, then I will be prejudiced and injured and damage will be caused. So in one of the earliest cases is Fletcher versus Bailey, where Pearson J stated that it admitted that the action is brought not to obtain damages for a past injury, but to prevent that which is feared as a future injury, or to use the more technical expression, the action is a quatimate action. So as we all know, since we have all now gone through the basic concept of injunction, the continuation of a past injury or a past wrong, you are entitled to an injunction only where damages are not an adequate remedy. But here you are seeking to restrain a future injury where the act of damage is not actually crystallized by the time you institute action. Alice J. in 1970 held that the relief sought by the plaintiffs is of some threatened concrete invasion of a party's rights, a cause of action that is available in quatimate proceedings, and that such an action is maintainable under our law. Now, one of the cases that has discussed this matter quite extensively is Ali Sappuhami versus Kahavidane, which is when Chief Justice GPS De Silva was not, before he became the Chief Justice. And that is, to put it in context, that was a case where the plaintiff, the defendant, commenced constructing a bakery and a hotel about 3 meters next to the plaintiff's land. So immediately the defendant commenced construction, the plaintiff went into court and took up the position that if the defendant is allowed to establish a bakery and a hotel, that would interfere with the rightful enjoyment of the property of the plaintiff. This is quoting from Justice De Silva. What Justice De Silva says is that the principle appears to be the same whether the alleged future nuisance is public or private. In some acts had been done which it was alleged would result in future mischief or injury, but which had not already resulted in injury or substantial damage. So in that case, in the context of the case, the construction of the building had commenced, but the business or the establishment of a bakery and the hotel had not commenced. So there was an apprehension that if a bakery was in fact established there, that would cause injury to the plaintiff, not only to the enjoyment of a peaceful, because it was a residential area, peaceful enjoyment of his property, but also might affect the general health. Then Justice De Silva says that in others, there was a mere threat or intention of damage being caused. But he says, in both cases, whether an act has already been committed, but the injury had not still happened, or there was merely an apprehension or a threat of a wrongful act, the principle is that where it is certain that the injury will arise, the court will at once interfere by injunction. But the court does not require absolute certainty before it intervenes. Something less will suffice. That he takes from Chitty Justice J in Attorney General versus Corporation of Manchester. The principle which I think this is Justice De Silva says, I think may be properly and safely extracted from the quatimate authorities is that the plaintiff must show a strong case of probability that the apprehended mischief will in fact arise. So it is not a mere imaginary complaint that has to be presented to court. The plaintiff must show that there is a strong probability that the mischief will in fact happen. Now, in that case, the issue, by the time, during those times, there was no enjoining order as such. By the time the permanent injunction was given, the bakery had already been established, and there was sufficient evidence at the trial that the health of the plaintiff was affected, as well as there were certain environmental issues that arose out of running the bakery there. This is a summary of what Justice De Silva says, that in quoting Hooper versus Rogers, it says, in truth, it seems to me that the degree of possibility of future injury is not an absolute standard. So you don't have to show as a absolute certainty that injury will take place if the defendant is allowed to continue with or to commence the act. What is to be aimed at is justice between the parties, having regard to all the relevant circumstances. Now, in that, there was a serious discussion. The two parties were represented by Mr. H.W. Jayawardena on one side and Mr. Renganathan on the other side, highly contested matter. The argument of Mr. H.W. Jayawardena was that if you do this, it would be in conflict with the known provision of law that a party, the party's rights are determined as at the date of action. So the issue was, if there was no injury that you are complaining of, and therefore there is no cause of action for you to restrain as at the date of institution of action, then there cannot be an injunction that can be granted by court. So Justice De Silva says this: while it is correct that rights of parties are generally determined as at the date of action, I find myself unable to agree with Mr. Jayawardena's further contention that the evidence led at the trial in regard to the existence of a nuisance is irrelevant, and that these facts are very relevant to show that the apprehension entertained by the plaintiff as at the date of the institution of action was justified and her fears were well founded. So there is definitely a conflict between the principle that the rights of parties are determined as at the date of action, as against instituting an action for an injury that would be caused in the future. But as Mr. Mohammed stated, Section 5 contemplates this. So your cause of action is not the actual injury that will happen in the future. Your cause of action is your apprehension of an injury that will be caused to you because of the wrongful act of the defendant. So your cause of action then arises at the time of institution of the action with your apprehension, which definitely has to be a strong apprehension, and you are supposed to prove that there is a strong probability that this will happen, but your cause of action is not the actual happening of an injury, but the future happening of a imminent injury. Now, again, if we put it in context, Sagarak matter, that is Felix Das Bandaranaike versus Ceylon Film Corporation. Now, that was a action based on defamation where Felix Das Bandaranaike sought to prevent the publishing or the screening of a movie which was a political commentary on what happened during the 1970 to 1977, and he went into court and asserted that if the film is permitted to be screened, the content of the film would be injurious to him. Again, Justice Sosa goes back to Fletcher versus Beeley and states these few facts. Of course, Felix Das Bandaranaike Sagarak, the case is being used as a seminal authority on the entire gamut of interim injunctions, but specifically with regard to Timet injunctions, Justice Sosa says this: he says that I shall be very far wrong, he does not think that he will be very far wrong if he lays down that there are at least 2 necessary ingredients for a coartimate action. So, for a coartimate action, there must, if no actual damage is proved, be proof of imminent danger. So, the first hurdle or threshold that you must satisfy, court, is that there is an imminent danger of actual damage happening. That has to be established. Then there must also be proof that the apprehended damage will, if it comes, be very substantial. So those 2 factors have to be established. One, that there is an imminent danger of damage happening, and if that apprehended damage does happen, that damage would be substantial. Justice Sousa goes on to say, it must be proved that it will be irreparable, because if the danger is not proved to be so imminent that no one can doubt that if the remedy is delayed, the damage will be suffered, it must be shown that if the damage does occur at any time, it will come in such a way and under such circumstances that it will be impossible for the plaintiff to protect himself against it if relief is denied to him in a coartimate action. So you can see how it has been structured, that what you need to prove is a little bit different from what you have to prove. Even this is also on a prima facie basis, from proving what has already happened. So you are trying to prove to court, even on a prima facie basis, of something that has yet happened. So because this principle came from the courts of equity, and justice between the parties was the main principle of equity, the courts will recognize the fact that there might be damage caused, and that damage will be irreparable, and most importantly, that if the courts wait until the damage is caused or the wrongful conduct has been carried out and the wrongful damage, the damage is caused, the plaintiff will be left with no relief at the end of the case, because you are going into court where damage has still not happened. Whereas in a continuing injunction, seeking an injunction to restrain a continuing act, if damages are an adequate remedy, I'm being very simplistic on that, there are more connotations to that, but in a normal action, if damages are not an adequate remedy, the actual cause of damage and the conduct that you are complaining of has already happened. Here, you're seeking damage on something that is yet to happen. So the burden is higher, true enough, but the courts will understand, the courts understands and give recognition to the fact that you are entitled, even if the damage has not been caused, you are entitled to relief to restrain that future damage. So, because of constraint of time, anyway, since we don't have to go into the basics of the principles of interim injunction, for a coartimate injunction that you need to seek, these are the fundamental matters that a plaintiff must prove to be able to obtain such injunctive relief. The first, this is the basis for all interim injunctions. In terms of section 54.1 specifically mentions that the plaintiff is entitled to and claims certain rights in respect of the subject matter of the action. So it is a sine qua non that you have to have a cause of action and a strong cause of action in respect of what you are in respect of the subject matter. Then the difference between a normal interim injunction, which is not a coartimate interim injunction, is that the defendant's intended act or conduct threatens to violate that right of the plaintiffs. So here is where the burden becomes tougher than a normal relief that you are seeking, because you have to prove that this is of course not the most difficult part in this journey, but that what you are complaining of will violate the right of the plaintiff, as well as thereby causing damage to the plaintiff. Then the defendant's imminent act of violating the plaintiff rights amounts to nuisance. This is in terms of section 54. The law says and the authorities say amounts to nuisance or will cause a damage to the plaintiff. Then the defendant's imminent act of violating the plaintiff right will cause an affirmative injury to the plaintiff. And what Justice Sosa says in Sagar Ahmed case is that you also have to prove that the damage that will be caused is irreparable. Okay, and therefore the plaintiff is entitled to restrain the imminent violation of the plaintiff's right. So the basic ingredients of the injunction is it's in this whole system of seeking a courtimate courtimate injunction. And also you must remember that courtimate injunctions, you are, as Mr. Mohammed also said, you are also entitled to a courtimate decree in terms of section 217 F of the Civil Procedure Code. So basically, this is what is there in the screen is what you have to prove. The difficulty or the greater responsibility when you're seeking a courtimate injunction as against, if I can use the word, a normal injunction, is that you have to have a strong case of what is called probability, that the probability of the wrongful conduct of the defendant in the future will cause damage to the plaintiff, and you're seeking the redress or the assistance of court to stop that damage being caused before the damage is actually caused. So if those things are satisfied, it is not too difficult to obtain a courtimate interim injunction. It happens a lot, I think, as Mr. Mohammed said. I would not say most of them are courtimate. I would say some of them are courtimate. And these sort of interim orders now, for example, in under the Companies Act, the section 232, if I'm not mistaken, specifically gives a party a right to seek a restraining order or from a court for an imminent threat of a violation of the provisions of the Companies Act or the provisions of the Articles of Association. That is for conduct that has yet not happened, and that is specifically recognized in the Companies Act, as well as I said, in terms of the section 54 of the Judicature Act. So this is a outline of a courtimate injunction, and I would be glad to answer any questions that might arise after Suren's presentation. Thank you. Thank you, Arindra.
Thank you very much, sir, for that presentation. Before we move on to our next speaker, I would like to remind our participants that depending on the time, we will be having a short Q&A session. So please feel free to post your questions on the Q&A box below or the chat box. And depending on the time, we will do our best to take as many as possible. Now, considering our topic for the evening, you may be wondering, how do we frame our pleadings if we are to seek a mandatory injunction or to obtain an injunction courtimate? What salient ingredients should go into those pleadings? And you may have similar questions like that. To answer these questions and to deal with other procedural aspects that pertain to our subject for the evening, we will now move on to our third and final speaker, Attorney at Law, Mr. Suren De Silva. Over to you, sir. Suren, your mic is off.
Thanks, Ayendra. Good evening, everyone. And First and foremost, let me first thank the Bar Association for inviting me to be part of this platform, especially along with such eminent senior President's Counsel. I consider it an absolute privilege and an honor. In order for me to just touch on the areas that I will be on in this section on Quia-Timet injunctions and mandatory injunctions and Quia-Timet actions, I would like to share a screen. Let me just, can the screen be seen, Ayendra?
Yes, Surya.
Chandaka,
Yes,
I think you're
it can be seen, yes.
It can be seen, is it?
It can be seen.
Okay, thank you. Yes. So the topic is mandatory injunctions and Quia-Timet actions. Before I deal with what is actually looked at or what should be gone into a pleading, let me also just recap some of the important matters that were touched upon on this aspect by Mr. Mohammed and also Mr. Jayasundara. So mandatory injunction is in fact to kind of compel the performance of an obligation or an act. It is not technically to restrain, but in order to compel the performance. Now, generally, as we are familiar with, injunctions are issued to restrain a specific act or conduct. But the mandatory injunction is generally not to maintain or preserve a status quo, but to alter a status quo in order to ensure that justice will be prevailed, justice will be done, pending an action or in a final judgment. Now, specific performance is also a type of a mandatory injunction that is actually granted by court, especially in contractual matters. But of course, in the cases where there is a possible delictual claim, so it would be the parties would be seeking an injunction in the form of mandatory injunction in order to compel the performance of a certain obligation or to restore the status quo. Now, Mr. Mohammed referred to some of the Indian cases. In India, unlike in Sri Lanka, there's a specific law, which is the Specific Reliefs Act of 1963, which has conferred the jurisdiction on the Indian courts in order to issue mandatory injunction to compel the performance of a certain act. We do not have such a specific law, but I think Mr. Mohammed extensively dealt with it. I will also briefly touch on it in my presentation. Similarly, Quia-Timet actions, as I think both the learned speakers said, is because he fears there is actually no injury or damage done at the moment. And as Mr. Jayasundara said, the mere paranoia would not suffice. There has to be some valid reason, and that there must be able to satisfy in your pleadings that there is actual or an imminent injury. So merely saying that, pleading that I fear that something's going to happen is not sufficient. You might have to give details that will be supported by some evidence and documentation in order to satisfy court that you are not just merely being paranoid and coming and using the time of court, but there is actually an imminent or a serious injury. And also very importantly, that the prospective damage of a substantial, if not irreparable kind. So that is, you must be able to satisfy in your pleading that the damage is such that you cannot be merely compensated by damages. Because as you know, damages, where damages is an adequate remedy, it's not that the remedy of damages is available, but it must be an adequate remedy. The courts would be disinclined in order to issue some kind of interim order. So Mr. Mohammed referred to this case, which is reported 12 NLR 16, that's a Ceylon Land and Produce Company versus Malcolmson, that case. It is in this case that the courts held that it is indisputable that an action Quia-Timet is maintainable in Ceylon. And if one reads this judgment, it also refers to certain examples and cases where in fact the courts have in fact entertained actions where there's a Quia-Timet, where there is only a threatened some kind of harm or injury that would be caused to plaintiff. And it refers to cases where in fact persons who fear that someone is going to file action or use a forged or fraudulent instrument in some action against you or in some other kind of form which can cause problems. So in that situation, the courts have is satisfied that these documents are in fact forged or fraudulent, the courts have allowed and entertained the Quia actions in situations such as that. Also, in this judgment, there is a reference to another case where a surety, before action has been filed against a surety, he has filed action to compel the judgment debtor in order to satisfy the debt because he feared that the judgment debtor will not pay, and also to call upon the co-surety to also to contribute to the common liability. Now, in an action of that nature, obviously, you would have to satisfy court that in fact the judgment debtor does have the money to pay and he is willfully trying not to pay in order to basically get the sureties to settle that liability. Another situation probably is, for example, say if your neighbor is trying to clearing his land to develop a condominium. Now at that stage, he may have not really started, but you fear that the development of a high-rise building next to your house could cause kind of damage. Now, merely coming and saying that's going to cause damage is not sufficient. So you would need in a situation like that to plead and also satisfy court that, for example, that the soil in that area is peat soil. It is in fact susceptible to flooding. There is also been another buildings of this nature which has been built in this area and that has caused damage to neighboring properties. And you know, that kind of evidence would have to be satisfied, and those kind of matters would have to be specifically pleaded in order to satisfy court, where you are trying to invoke the jurisdiction of court seeking some kind of a Quia intervention of court because you fear that there is going to be some kind of damage that will be caused to you, which is not caused, but you feel and that it could happen. Now, the general principle in this is that the courts would consider it unreasonable for a man should he always have a cloud hanging over him. So you must be able to satisfy that it would be unreasonable to expect me, the plaintiff, to wait till actually the damage happens, the building comes up and it happens, and you always in fear, is it going to damage my house? I'm the only house I have nowhere else to go. My means are not sufficient to find alternative abode if something happens to this house. So those kind of matters you need to be able to satisfy. So merely coming and just saying that I'm going to, I feel that this is going to cause damage to my house or my property is not merely sufficient. Now, and also on that light, I think it's also sometimes you might have to get a structural engineer's report to come and satisfy court as to why building a high-rise building of that nature maybe or could cause damage to your house or to the residential, to other areas, to any other houses in that area. Of course, if it's going to be such a situation, there could be a collective action where some of the other residents also join you as the plaintiff. Now, as Mr. Jayasundar explained, in a Quia action, it is not that the court must be absolutely certain that this damage would occur. Even something less would suffice. All you must show is that there must be a strong case of probability that the apprehended mischief may arise. So I think these are very important matters that one has to take into consideration when one is drafting the pleading, and also that there's necessary evidence that is annexed to the pleadings, whether it is by way of plaint or petition, to satisfy court that these ingredients are actually that your threat, the fear that you have is not something which is misconceived or misplaced. Now, going on into the laws and the procedures, as I think was extensively dealt with, Section 54 of the Judicature Act is what confers the jurisdiction to the original courts to grant injunctions. That is the High Court, District Court. We don't have a small claims court at the moment. And a court would grant an injunction in terms of Section 54, restraining a defendant from committing or continuing a wrong, an act of nuisance, doing or committing any such act or nuisance, or removing or disposing of such property. Now, that is where you file action to recover some monies from person, the defendant, and then in the interim, the defendant tries to transfer his properties to his wife or children or somebody in order to kind of defeat and to ensure that even if you're successful, that you may not be able to reach out and be able to have your judgment satisfied. So that is also one instance where an injunction could be granted restraining. So, but as I think Jayasundar said, it is not only to restrain only the commission, but also where there's a threat of that the damage or injury would occur. So it is not only where there is actually damage suffered, the act has been committed, but also where there's a threat that damage or injury would occur. As Mr. Mohammed explained, in the case of P. Risnada versus Pereira, the Court of Appeal, Justice Ullagama, specifically says that although one finds the word in section 54, the word is restraining, that in certain cases, restraint envisages a positive act. So there's very clearly has been now ingrained in our law that a mandatory injunction could also be obtained in terms of the powers conferred under section 54 in order to not only restrain on probably to maintain a status quo, but also to alter a status quo where you could satisfy court that there has been some grave injustice or mischief that has been caused to you. The injunctions can be applied for and obtained at any time before a final judgment is given. And where I think most of us who are practitioners are aware, where there is the objective of granting an injunction will be defeated by delay, the court may issue an enjoining order, which is initially for not more than 14 days. That is where if you feel you give notice that the defendant might try to expedite and carry out the wrongful act in order to ensure that before the court action is filed and an enjoining order is obtained, that the wrong that is sought to be enjoined has already been converted into something else. So in fact, by doing that, the granting of that enjoining order, the interim injunction, would be defeated. Now, in addition to section 54, another power provision that is available to grant injunctions is the power granted to the Court of Appeal in terms of Article 143 of the Constitution. Now, Article 143 of the Constitution has conferred jurisdiction to the Court of Appeal to grant injunctions to prevent any irremediable mischief which might ensue before party making an application for such an injunction could prevent same by bringing an action in any court of first instance. Now, you would wonder why when this kind of situation could arise. Now, those of you familiar with having filed actions against the state would be aware that before you file an action against the Attorney General, against the act of a minister, deputy minister, or a public officer, you have to give us what is called a section 461 notice, a notice which is a 1 month notice, and you cannot file action against the Attorney General on behalf of any of these people until that notice is given. So what do you do in such an instance? You will go and invoke the jurisdiction of the Court of Appeal, and you would seek an injunction to prevent that irremediable mischief. I remember an example of one of these cases was when I was in the state, was where the government had decided to distribute certain counterfeit cigarettes which the customs had seized and forfeited, which have been illegally imported into the country. So the government decided to distribute these to the security forces. One of the leading tobacco companies in the country came to the Court of Appeal and invoked this jurisdiction and got an injunction against the AG, preventing them from preventing the customs from distributing these cigarettes on the basis that if these come into the market, then there could be a serious it could cause serious violation of their rights, because people will go and buy some of the fake cigarettes thinking that they are in fact the products of the plaintiff, the petitioner. So in that was the instance I remember where it was invoked, and in that case I remember Mr. S.L. Gunasekara, who appeared for the petition in that case, to remember him saying, why doesn't the government in fact distribute gold when these are illegally imported and seized? Why only cigarettes to the soldiers? I still remember that in his customary style. So section 461 that is one of the instances where you could actually go to the Court of Appeal and invoke that jurisdiction of the Court of Appeal, where you cannot immediately go to the Court of First Instance in order to prevent an irremediable mischief that will be sustained. Now, given the current, pandemic situations and quarantine situation and lockdowns, this may be a situation where, for example, even now, where if a certain area is which would have the territorial jurisdiction to hear a cause of action, your cause of action, and that area is locked down. So that would also be a situation where you could invoke the jurisdiction of the Court of Appeal, because you are prevented from bringing that action in the court of first instance due to the fact that the courts are locked down during that time. Now, coming to the procedure, let me first, as most of you are aware, Section 662 of the Civil Procedure Code says that every application under Section 54 of the Judicature for injunction has to be by petition and affidavit, except where an injunction is paid for in the plaint. So if it is in the plaint, then you can seek and pray for the injunction in the plaint itself without having to file a separate petition and affidavit. The plaint has to be accompanied by an affidavit of the applicant and some person who having knowledge of the facts and containing statements of the facts. So as I indicated earlier, where you are seeking some kind of interim relief before the court has the benefit of the full complement of justice of the evidence, you need to satisfy court through your pleadings, accompanied by the necessary documentation and proof, affirmed to or deposed to by an affidavit, to satisfy that there is sufficient reasons and justification for the court to exercise its jurisdiction and in order to issue an interim injunction or an enjoining order in the first instance. Now, one important aspect that the court would obviously also look into, and which you need to satisfy court, is that you must be able to satisfy the court that the enjoining order, the interim injunction, or even the injunction could be enforced by court, because the court is not going to make an order in vain. Now, for example, in the case that I cited, where the government had decided to distribute those cigarettes. Now, if by chance the government had actually distributed the cigarettes to the soldiers, and if the plaintiff came to court, the court would have most likely told the plaintiff, there's no way that I can enforce it now, because now it is in the hands of so many people and there is no practical way that I can enforce it. So you must be able to satisfy that this order that is going to be issued by court can be enforced by court. Now, how do you enforce that order? It is set out in Section 663. It is by punishing an offender for disobedience of an order of court. So it's by being able to ensure that the court can punish the wrongdoer who acts in disobedience of that order of court. So that is also a very, very important aspect that you need to be conscious of when you are drafting your pleadings, and also when you are supporting an application for some interim orders, or even interim order, especially that the order you are seeking can be enforced by court. Then what happens? What are the rights available to a defendant? Now, before an injunction, especially with the interim injunction or a permanent injunction is granted, first and foremost, the pleadings along with the affidavits have to be served on the opposite party. An interim injunction and a permanent injunction will never be granted ex parte unless, of course, there has been a default in appearance, the defendant who has been noticed. And as I said earlier, where the objective of granting an injunction would be defeated by delay, the courts would not hesitate to grant an enjoining order, which will not exceed more than 14 days at the first instance. So now, once the plaintiff has obtained an enjoining order against you, what do? Now, when you support for an enjoining order, or in the initial instance, what you would be asking court is for summons. That is, the summons would be on the main case, the final substantive relief. And if you are, obviously, you'll be asking for an interim injunction, which the court is not going to issue ex parte. So the court will be supporting for a notice of interim injunction. And if you are successful in obtaining an enjoining order, then you will be serving the enjoining order that you have obtained from court on the defendant in the first instance. So once the defendant is served with this document, then the defendant has the option of waiting and filing his objections to the interim injunction, and thereafter getting an inter partes order on the interim injunction. If the defendant feels that this is going to cause further prejudice and delay, then the defendant could come to court and file an application by petition and affidavit invoking section 664(3) to suspend the operation of the enjoining order. But of course, one must be mindful, section 664 subsection 3, you can only invoke and get it suspended where there has been suppression or misrepresentation of material facts. It is not on any other grounds, it is confined to that. But those of you who are in practice would be aware that when you are making an application to have it suspended, an enjoining order suspended, you would also be invoking section 666 of the Civil Procedure Code, which confers the jurisdiction on the court to have an enjoining order discharged or varied as well. So a person who is dissatisfied would also invoke section, not only section 664(3), but also section 666 in order to have the enjoining order which was issued ex parte discharged or varied. Now, even if an interim injunction has been issued without proper notice and hearing the defendant, then that defendant who is dissatisfied could also come and move to have the interim injunction set aside, provided of course he can purge his default. However, section 666 cannot be invoked where an injunction or an enjoining order has been made inter partes. So if on the day that the enjoining order has been supported, if the defendant is in court and the defendant enters an appearance and argues and makes submissions and is unsuccessful, then you cannot come and invoke section 666. Then you have to go and file a leave to appeal application in the civil appellate courts. So where it is inter partes, section 666 has no application. But where it has been, an order has been obtained ex parte, then a party should first canvass that order before the original court. So as I said, and also if section 666 does not confer powers or jurisdiction to the original court to suspend the operation of an enjoining order or an interim injunction. Then section 667, the section that has given powers to the district court, to the original court, to award compensation where an enjoining order or interim injunction has been obtained without probable cause for the expense and injury that has been caused to the plaintiff to the defendant by the plaintiff having come and obtained such an enjoining order, interim injunction without a probable basis. Now, coming to some practical aspects, when one is pleading and drafting their pleadings, seeking injunctions, is that the interim relief should correspond with the final relief, the final permanent relief, because you are seeking these interim reliefs until the final or the permanent injunctions are granted by court. So if your interim relief differs or is something different to the final relief, then in most situations the court will refuse.
Suren, if I can interrupt you for a moment, we are running short of time. If you can take 2 minutes and wrap it up.
Yes, I will quickly wrap. So that is something that is important, so that the reliefs correspond with the interim reliefs correspond with the final relief. Now, one of the objections that plaintiff would generally face in most of these cases is where the defendants may come and seek to contend that the interim relief you are seeking is in fact the final relief. Now, this was gone into in the case of Shell Gas Lanka Limited versus Samyam Lanka. I will quickly, just give me 2 minutes, I will quickly wrap it up. Very briefly, this was a case where the plaintiff had supplied and installed what is called a large LPG bulk vessel in order to provide LPG to one of its industrial customers. The customer defaulted and the contract was terminated, but then the defendant tried to get products from a competing LPG supplier and use the same bulk gas vessel. The original court said when an application was made seeking to restrain the defendant from obstructing the plaintiff from removing this vessel, the court said that in fact you are trying to get the final relief at an interim stage. However, in the Court of Appeal, their lordships held nevertheless that when it appears that there is no defense for the defendant and there has the breach and that the defendant is acting in breach of a covenant, it is not contrary to our law to grant an interim injunction even if the granting of the interim injunction would result in granting the plaintiff the substantial final relief. So that is a very important judgment where in fact the courts in fact altered the status quo and granted interim injunction, which was more or less the final relief paid for in that case. So I will just stop there, Indra, because of the time. Thank you very much.
Thank you very much, Suren, for that presentation. I think we have a few questions. Maybe we can take 10 minutes and answer them. The first question is, what constitutes substantial damage? Is it an objective standard? Mr. Jayasundar, can you answer that? I think it's in the context of the ultimate text.
In fact, it's not objective, it has to be subjective, because if you read Justice De Silva's judgment in Arli Sappuhami, he says that, and he discusses a lot of English cases also, and he specifically says that the determinant factors that a judge should consider will be on a case-by-case basis. So the substantial damage will be dependent on what the case is and how it might interfere with the rights of the plaintiff. It's not objective.
Thank you, sir. Mr. Mohammed, you mentioned that in the case of Pires versus Pereira, that His Lordship Justice Uddulagam mentioned that normally mandatory injunctions are granted as ancillary to a prohibitive injunction. Now, does that mean that you cannot pray for a mandatory injunction as an isolated or a standalone relief?
That's a good question. Although that apparently he had made the statement, Justice made the statement in the circumstance of the case, because there was an initial order made that was nullified by the act that they had by his conduct in putting up that wall in no time. Therefore, he said if it is necessary, where it is ancillary, court will not hesitate. But I don't think that should be limited to that. If there's an example, there was a case in Mount Lavinia where a person purchased the property and then he wanted the tenant to vacate. When the tenant did not vacate, as a owner, he had gone and he put a barbed wire across the swimming pool that was there in the premises where he was running a hotel business. They obtained interim injunction, a mandatory injunction to remove. And when I appeared and argued that interim injunction of that nature should not be issued, court said, Mr. Mohammed, by the time you go home, if there is a construction that is placed across the road, are you going to stay until the case is finalized for you to have access to court? And court even, in fact, Justice Vimal Chandra refused to grant even notice, which I believe is the correct law. There was nothing ancillary. They made directly an interim order was granted to remove the barbed wire fence that he constructed across the swimming pool. I think the in order provisions are wide enough to grant mandatory order per se.
Thank you, sir, for that answer. Suren, you also mentioned the fact that where damages are an adequate remedy, court will not grant injunctive relief. Now, in a situation where, I think anybody can ask this question, situations where, say, a person has put up an obstruction like a wall, as Mr. Mohammed mentioned. In that situation, can a person ask for damages for the loss and damage that he or she suffered until that wall or whatever impediment was removed by way of mandatory injunction?
The mandatory injunction would be to, in fact, if the wall has been illegally erected, would be to have it demolished. I mean, if you are able to satisfy court that the defendant does not sufficient have a proper defense, and even that you are entitled to at the interim relief, then the courts will issue it. But if you are not able to convince court at that stage, at least in the form of a final relief in order to ensure that it's demolished. So whatever damage that we have sustained as a result of it, then, I mean, if it means having to demolish it, you have to spend money and cost, and whatever other damages which you can prove, then obviously you might be able to succeed in getting damages, because he who asserts must prove. So you cannot just only throw numbers at the head of court. You need to be able to prove what's the damage that you have sustained.
I think the question was, quite apart from the expense that will incur in demolishing the building, if because of that, if a party has lost, For example, if you have put something due to which you could not open the shop for purpose of doing your business, I believe they want to consider the loss can be claimed. I'm sure you are able to claim, which is not related to the injunction, is not based on the ground of damages, but I believe damages is claimable up to the point of where the interim injunction, by virtue of the interim injunction, that obstacle is removed. Is that, Mr. Jackson? It should be so, no?
It should be, sir. But then, of course, when you go on down that road, they will say, no, now if you can quantify it up to that day, that means your damage will be quantifiable, and therefore, so that is a situation where this issue of adequate adequate damage, whether damages will be adequate. That is why you seek injunction, is that because even if damage has, and you are entitled to damage, the damages that has already been caused, continuation of this means that the damage, whatever the damages you are entitled to, is not adequate. Ayendra, if I can take this opportunity, one other problem in these mandatory injunctions and the reluctance of court and the defenses taken up by others, by the defendant most of the time, is that you are obtaining the final relief at the interim injunction or the enjoining order situation. But its circumstances, it like, again, we come back to the position that the damage that will be caused if the court doesn't take this extraordinary step of either mandatory or a coartimate injunction, the damage that will be caused cannot be, it's completely reparable. So that's because most of the courts, you go and ask for a mandatory enjoining order, they will say, but you are getting the relief after this, what is supposed to happen. So it's the inadequacy of anything else that the court must give a mandatory injunction or a coartimate injunction.
I think in that respect, the judgment you cited just the judgment, no?
Correct, sir.
No, that they say
where
the right is clear. Where you have that order, the fact that it is the final order should not debar you from getting it, and he cites some English authorities.
English authorities cited, sir, because in that case, he took up the position that the defendant has been unable to establish a viable defense, because if you follow
there is no defense at all, quite so.
Because the defendant admitted that the bulk vessel was owned by the plaintiff, admitted that it was terminated, so there was actually no defense. So in a situation such as that, the court was said, we are not going to willfully shut our eyes and wait because of the damage and the injury that would be caused, and we will alter the status quo and in fact allow it, remove it. Now in that case, it was more than the mandatory injunction, but as you said earlier, it was an injunction that was sort of restraining the plaintiff from obstructing, restraining the defendant from obstructing the plaintiff from removing it. So then getting the plaintiff to defendant to give it, the defendant decided, I will spend money and remove it because it was still beneficial. So you're getting the same outcome by getting a negative injunction and by you being able to not be obstructed or interfered with to go and exercise your rights. So I think that is it's a very important aspect.
Quite a good judgment. Quite a good judgment. Progressive judgment. Hope other judges will follow it.
Yes, because especially I think in matters where I remember, I mean, in cases land law, I mean, property matters, the founders of Ganegama is very clear that you can't dispose it. But I think there are a number of situations.
I think Mr. Estelle Silva's article is very useful. And, I think all of us must go through that and make use of it in our courts.
Because otherwise, if people sit and they spot for years and years and you are deprived.
Wait till the final judgment.
Until final judgment.
Mr. Jayasundar, you have to satisfy court and get orders. Interim orders of this nature and progressive orders.
You are the past master for that, no, sir?
Thank you, sir.
The present master also.
If I can pose another question to you, gentlemen. Now, it was said that where a person violates a mandatory injunction, the recourse is to file for contempt proceedings. Now, is there any other recourse available to a person, an affected person, where the defendant violates a mandatory injunction apart from contempt proceedings?
That is basically also, that is why I said in drafting papers you have to be careful, get an order to break the a mandatory injunction to comply with that. And you can also in that plead, in the event the person fails to comply with that, you be permitted to break, demolish.
It always has to be in the alternative.
So it's drafted in that way because in certain circumstances, but also the jurisdiction, contempt jurisdiction is wide enough even to compel that person to break that or comply with that and to punish that person until compliance, which was done in one case, I believe. That's if you see judgment reported in 43 NLR 366. That's an injunction issued by the Court of Appeal or Supreme Court in terms of Article 143. And without the non-compliance of that, they came to court and they asked that person be directed to comply with that and to break whatever it had be constructed or supply of water, to give the supply of water which he has stopped contrary to injunction in the contempt proceedings, and the court made order that he must comply with that. So contempt proceedings, although we don't use it, I think it's wide enough if you examine. The punishment is among others, like, so you contempt proceedings, court could take steps in that circumstance to compel them to comply with that until such time he can be sentenced.
I think the question was whether there was any other provisions. So I think the 663 provision is what is available to enforce. I think in the Civil Procedure Code is the contempt aspect. Because I have not come across any other provisions, sir, in order to enforce an enjoining order, interim injunction, or an injunction against the defendant, other than
that's the only
fear of a contempt application.
But Suren, that is in the context of a normal restraining injunction. No, I think Mr. Mohammed was speaking about a mandatory order where the mandatory injunction or injunction is not adhered to. Then you compel. It's like the decree you have 233 or somewhere down the line where you can ask for the registrar to sign deeds and to give effect to even a declaratory judgment to give effect to it. You can ask court to give
alternative, quite so.
So
that is where, you know, we have, as lawyers, we have to be very carefully, we must think of, because the defendant is also entitled, and he would keep a lawyer who is as good as you or who drafts the papers. They will contemplate what the action that they will take in defense, and then accordingly do a little bit of more pleading. Prayers won't harm, unless unlike asking for a lesser prayer.
Thank you, sir. Mr. Jayasundara, in the context of Quia Timet actions, the question is, can a person obtain a Quia Timet injunction in the form of an enjoining order, especially considering the burden of proof to establish a Quia Timet or to prove a future damage is so high? Would the court be inclined to grant an enjoining order ex parte without hearing the other party?
The thing is, this Quia Timet, unlike the mandatory injunction, Quia Timet injunctions are not very difficult to obtain. The fact it is recognized that it's just that, as Suren also said, it's you can't go to court on a paranoid with your paranoias or imagination or that your that something is going to happen. You must have some substantial evidence to show that the conduct of the defendant will lead to this and nothing else, right? So it's not that you have to, the burden is so much greater than a normal injunction, but there has to be something, it's still prima facie, right? It's not like the Indian, I think the Indian mandatory injunction, Mr. Mohammed said that you needed a bit more than or English, you need more than a prima facie case. For a Quia Timet injunction, you don't need that, because Justice De Silva in Ardisapu and the earlier cases, they say it's not an absolute that you prove these things, but you must show something. You can't just go and say this might happen or this might not happen. So, for example, if it's a defamatory action, there will be maybe the notice of a publication, or maybe now in these days of the internet and YouTube and all that, you might have knowledge that a certain interview has taken place, or it has been filmed or videoed and it has not been uploaded. So there is an interim period where you can't just go and say somebody that that fellow might publish this statement. You have to, any case, you must have some prima facie, but it's not a huge burden. It's just that it's a substantial burden. It's not an insurmountable burden.
Now, in that context, I think Ms. Jason, Justice Sosa in Felix Bandana's case puts it so beautifully in his finally in his judgment. In the instant case, the plaintiff is complaining about scenes and episodes in a film he had not seen. Apparently, he is going on what others told him. He is anxious to take the film himself to pick out what is defamatory of him. There are no affidavits before court of what the film contains from persons who have seen it screened. In any event, the exhibition of the film is a long way off. In these circumstances, too, an interim injunction cannot be issued. So there is some prima facie evidence before court of some that danger being imminent.
And we must thank Justice Sosa for not restraining the film, because that was one of the best films of the age.
One of the finest films.
Ayendra, just to add on to what I think Mr. Mohammed and Mr. Jayasundara said,
Yes,
it is also important. I think there is a judgment of justice before His Lordship Justice, Deputy became the Chief Justice. Gee Kiyanage Tanuja Sanjeevani Amarasinghe versus Pirosha Prashadini Kahandawarachi, which is SC HCCA LA 346 of 2013, which is SC minutes 31st of March 2015, where His Lordship said that even if where you have applied for a enjoining order or an interim injunction, and it has been refused, but if there are new circumstances or fears or threats that come about, which can be justified, that does not prevent you from filing and seeking making a fresh application for an enjoining order or interim injunction based on this new evidence. So even initially, if your threats and you felt the court feels that you are being premature, but if later on something else transpires and there are fresh ground, then in terms of judgment, the court says that you can come back again and make an application, a petition and affidavit to get an enjoining order or an interim injunction.
Thank you, Suren. Well, gentlemen, I think that's all the time that we have for today's discussion. Before I hand the proceedings back to Shania, I would like to once again thank our esteemed panel of experts for having blessed us with their time, their effort, experience, and knowledge. I'm sure all of us benefited greatly from this discussion. And I would like to thank the Bar Association for having invited me to host and moderate this webinar. So with that, I would like to wish all of you a pleasant evening, and please stay safe. Over to you, Shania.
Thanks, Ayendra.
Thank you, Ayendra. This was indeed a very informative, interesting, and insightful session on the topic of mandatory injunctions and Quia Timet actions. On behalf of the Bar Association of Sri Lanka and the Seminars Committee, I would like to thank our wonderful panelists for this evening, President's Counsels, Messrs. Ikram Mohammed and Chandaka Jayasundara, and Attorney at Law, Mr. Suren De Silva, for readily accepting to speak at this webinar and sharing their valuable and knowledge and experience. I would like to thank all of you who joined us, without whom this webinar would not have been successful, and for your questions that have made this webinar an interesting one. Thank you, everyone. Join us again next week on Saturday at 5:30 p.m. for the 60th webinar in this series on an equally interesting topic. Good night and stay safe.
Thank you very much.